Good morning. Welcome to Outline. Apologies, we're running a few minutes late starting for those watching the live broadcast. We have a minor technical issue in that my co-speaker is having trouble getting into the Zoom site. So if you could just bear with us as people are joining, and hopefully we will be ready to start in the next minute or so. Apologies again to those who are just joining. We've got a technical issue this morning. We're just trying to get my co-speaker into the webinar, and then we'll begin. So please do just bear with us. We'll be up and running shortly, I hope. Again, apologies. I'm hoping my co-speaker will be joining me imminently so that we can begin the seminar. For those who have just joined, good morning. Apologies, we're having a slight technical hitch with my co-speaker getting into the system, but I am told that he is in the process of logging in. Hopefully, the issue will be resolved very shortly. I, I do apologise, and everybody hanging on there. Thank you for waiting. I'm just waiting for an update on where the technology issue is with my co-speaker, Ian Graves, who is struggling to get into the system for some reason. But apologies again, and please do bear with us. Yeah. Ian, can you hear me?
Can
Nice to see you.
Sorry to be
Well,
late.
it's a no problem, but we're going to go straight into it. So, everyone, apologies again for that. Ian had some technical issues this morning, which meant that he was struggling to get in, but he is now here. So, without further ado, thank you for your patience and for bearing with us, and welcome to this month's edition of Outline, DLA Piper's regular series of planning law updates. This month, we're looking at the topic of commercial NSIPs, nationally significant infrastructure projects, and Section 35 of the Planning Act 2008. And we're looking at that particularly in the context of the discussion that has happened really since the change of government in the middle of last year around the extent to which data centres, gigafactories, laboratories, and other sort of knowledge economy and growth sectors should or shouldn't be included within the development consent order regime. I'm delighted that I have been joined. It's looking touch and go there. For a minute, I thought you were going to get a 45-minute monologue from me. I'm delighted to have been joined by Ian Graves, legal director in the DLA Pipe planning team, and a specialist in all things NSIP and development consent order related. So, Ian, welcome and thank you for joining. Much relief to me, and more importantly, I suspect our audience didn't want to hear from me for 45 minutes constantly. Um, so we will, as ever, we try to keep these within 45 minutes to an hour, and we will definitely make sure we do that, notwithstanding the fact that we're 10 minutes in already. So without further ado, let's get going. And Ian, really, perhaps place to start is just a bit more context to why the government has consulted. It obviously consulted as part of its changes to planning, the MPPF and other changes at the back end of last year, consulted on whether data centres and other forms of development should be DCOs. So perhaps just could we start with a bit of context as to what the government's thinking is as to why this is an issue that needs to be considered now?
Sure. So, as you say, part of the government's consultation last year was mainly focused on the NPPF and other sort of aspects of planning reform. One of the questions that was asked is, to what extent should things like data centres, gigafactories, and laboratories be directed into the NSIP regime, so the Planning Act 2008 Development Consent Order regime. And I think we've obviously put the focus on data centers in terms of looking at this issue as an example. But the proposal extends also to gigafactories and laboratories. I think that the thinking in the consultation was not that those sort of developments would automatically become NSIPs, but that they would be subject to Section 35 of the Act. So I'm just getting a message to say that my audio is not very good, Trevor. I don't know whether you finding that.
It isn't, Ian. I was wondering whether it was my speakers or your audio, but if that message is coming from others, it's not great.
I'll try putting on my headset.
All going well today.
Yeah, I can't do that. It's ironic, isn't it? We're talking about data centers now. I'm plagued with IT problems.
Probably a
Um,
lack of data center capacity is part of the problem.
So the proposal from the government was to expand the scope of Section 35 of the Planning Act, and this is a power that enables the Secretary of State to designate other types of developments that wouldn't ordinarily be NSIPs as NSIPs. So the idea really would be to give more flexibility to data center developers to allow them to bring those sort of developments within the infrastructure planning regime. I think looking at those three types of development, I think it's pretty clear actually that gigafactories and laboratories definitely definitely can't come within the regime, can come within the regime rather. But it's slightly less clear in the case of data centers. So I think the government is looking for a way to make that more certain for developers.
And I think it's probably worth saying that the way that the NSIP regime works, there are a series of thresholds for different types of development. And so there are certain, if you're over those thresholds, then you are an NSIP and you have to go down the DCO route. I think sort of for the purposes of this discussion, it's probably just worth noting there are certain circumstances in which a data center or a gigafactory or whatever would have to be a DCO because it is an NSIP. And an example of that would be around power generation. So if there was sufficient generation on site to take it over the energy project thresholds, then there would be no choice. So I think sort of context for today's discussion is we are assuming that the project that you're considering has that choice under Section 35 rather than being forced into the DCA regime by virtue of one of the other thresholds. There aren't any thresholds that directly apply to, say, a data center, but there are those like in the generation space where if you were doing sufficient energy generation on site, you would find yourself caught. So we'll assume for now that there is a choice. And this is very much, I think, Ian, as I sort of understand the government's proposal, it is aimed at clarifying that choice and making it clear, not forcing data centers necessarily into the NSIP regime, but providing a choice to someone bringing forward a development as to whether they want to go down the normal planning application route with the local planning authority or whether they wish to promote a development consent order via the Secretary of State.
Yeah, absolutely. And I mean, it's always been clear since the changes to Section 35 that came in the sort of early 2010s that the intention of that power in the Act is to give developers flexibility. So, there will be certain circumstances where the right choice for a particular project will be a development consent order, whereas for other projects and for many sort of smaller data center proposals, I expect this would still be the case. The Town and Country Planning Act is still the most suitable route.
So I think sort of looking at what are the consequences and what are the pros and the cons of a DCO, and I think sort of traditionally for me, the pros of a DCO, it is a more certain process in terms of timing. There are statutory timescales within which you will get your decision. There's quite a lot of front loading that goes in before that, but the actual application process is more certain. I've often sort of said as well, DCO quite often feels to me as if it's planning without the risk of failure. The outcome, as well as the length of time of the process, is perhaps more certain than planning. A traditional planning application has historically been, certainly in the last few years, where it's been quite unpredictable as to how, on an appeal, for example, a Secretary of State might decide a particular planning application. The other big advantage that always strikes me is the DCO, of course, is more than just a planning permission. You get your consent to build and avoid the need for a separate planning permission, but you can also roll up other consents and other orders that you need. So if you needed compulsory purchase powers, you can be granted them through a DCO. If you needed various highways orders, if roads needed stopping up or things need diverting, those sorts of issues can be dealt with in a DCO rather than a separate order process needing to be followed. So that's always struck me as some of the benefits of a DCO relative to a planning application. I kind of wonder though the extent to which some of those are going to be generally applicable to say a data center or a gigafactory. Things like CPO quite often, particularly for a data center, it's a relatively small land take, and that tends to be something that's relatively easily done without resort to CPO powers. It's not like you're delivering a sort of railway line that's running for hundreds of kilometers and needs to acquire all sorts of different land interest. But nonetheless, I suppose if you've got title issues, covenant issues, those CPO powers still can be helpful. I guess the other thing for me at the moment is actually the appeal system is working quite efficiently in my experience at the moment. The inspectorate is determining appeals quickly. And certainly since the general election, there is a very pro-growth, pro-yes approach being taken by the planning inspectorate and by the Secretary of State, and we've seen that. We recently did a seminar on the Court Lane appeal decision that I was involved with other colleagues in the team. That was a very strong yes from the Secretary of State and a very clear message. So I sort of wonder at the moment whether, in most cases, there's going to be a benefit to using a DCO. It's not to say it's not a good idea to have the choice, but I sort of think there's quite a key decision that needs to be made by anyone quite early on in the process as to whether the cost of a DCO is justified in a particular circumstance.
Yeah, and I think it's cost, but also it probably is a slightly longer process. I think what you buy with the longer process is greater certainty, as you said earlier. I mean, I think probably the most obvious advantage is the ability to use compulsory acquisition. So, if you did need to assemble a site, whether that's for the data center or for sort of associated infrastructure, and you can't do it through market agreements, then it is possible to use compulsory acquisition, which is obviously something that's not available through the town and country planning system. And equally, as you've said, there is the power to amend legislation. So, if there are any particularly sort of problematic pieces of legislation, particularly local legislation, they can be amended. And also, it's a one-stop shop so that you can roll up your other consents into the one development consent order. So they're all the advantages. I think currently, as you say, the scale of data center projects probably doesn't naturally lead you to taking advantage of a lot of those issues. I think one of the things, obviously, is looking at the way that the market might develop going forward. Clearly, data centers, for example, are hugely sort of in demand with things like the growth of AI and other sort of data heavy parts of the economy. And so, inevitably data centers will grow bigger, I think, over the next sort of 5 to 10 years. I think that's pretty clear when you look at the sort of trends in technology and so on. So I think those powers might become more relevant as we go forward. And I think probably one of the things that the government is looking at is a more sort of future proofing of the system, because as they grow bigger, all those advantages will grow in importance, and also this will be a sector of the economy that will grow in importance for the UK. And obviously, stuff that is covered by the Planning Act 2008 is by definition the types of development that the government thinks is nationally significant. And so you have the advantage of a national decision maker who is making decisions on a national basis rather than a local basis.
There are some sort of other benefits as well, aren't there? I think it's certainly at the moment, a DCO avoids BNG, for example, and whether that lasts, I'm not sure, but certainly at the moment you can avoid the BNG requirements.
Yeah, so they're not enforced for NSIPs. I mean, I think that the previous government had suggested that November of this year they would come into the requirements for NSIPs are slightly different anyway. So the government needs to introduce a biodiversity net gain statement, or amend the relevant national policy statements to make provision for biodiversity net gain. The previous government, as I say, committed to November 2025. I've not seen anything officially that suggested that that won't be the case, but equally, there hasn't yet been a consultation on what that regime will look like. So, of course, it's always possible that there'll be a delay. Certainly on larger projects, biodiversity net gain requirements are substantial. So, you could be looking at a significant cost saving in that sort of area.
Yeah, and what about and this is a question for you, because this particular bit's very much your speciality rather than mine. But one of the challenges, whether you're a gigafactory or a data center, is your grid connection. Are there opportunities to use a DCO to circumvent some of the delays that developments find in terms of getting their grid connection and getting powered up?
I mean, certainly in terms of development of the infrastructure, but I mean, this is where it sort of gets quite interesting, isn't it? Because I mean, for example, a grid connection in terms of overhead lines would be probably a nationally significant infrastructure project in its own right. With NSIPs, if you go over the thresholds set down in the Act for particular types of infrastructure, and electricity transmission lines are one of those, then you would become an NSIP. So you might actually be forced into the regime anyway, if your, for example, overhead line is big enough. But I mean, other infrastructure such as substations, for example, isn't automatically an NSIP. But I mean, if you had a Section 35 direction relating to your data center, you could certainly include a substation as what's called associated development. So you would be able to get one permission for that, yeah.
Interesting. We've had some questions coming through, some of which we can pick up at the end, but one that it's worth sort of touching on now is around CPO powers, and the question is whether those CPO powers could extend to rights over land rather than actually acquiring land itself. So if you've already owned the land, but it's subject to whether it's minerals rights, easements, or anything else, and the answer to that is yes. Your CPO can be used to effectively clean the title of land by acquiring those rights that exist. So I think the short answer for me to that question, while we're touching on CPO, is absolutely. It is still a useful tool, even if you've already acquired the land, but you can get rid of those covenants or other things that might prevent the development or might act as a ransom. And of course, there's compensation payable, and don't think we should get into the how you calculate compulsory purchase compensation today. That's a topic, at least one session in its own right. But yes, subject to that payment of compensation, you absolutely can use those CPO powers to resolve any rights restrictions on land that are affecting or impacting your ability to bring development forward.
Yeah, I mean, the powers of compulsory acquisition under the NSIP regime are very flexible, and for example, include powers to use land temporarily, for example, which under a sort of regular CPO aren't enforced yet. So, I mean, there are lots of probably the main benefit, I guess, for these types of development currently would be around land assembly, overriding of rights, acquisition of rights, and so on.
The sort of in terms of the downsides, why do you not use a DCO? And I think it is anyone who hasn't dealt with a DCO before should not underestimate the intensity of the effort that goes into it. It's very much a front-loaded process. So whilst the application has a clear statutory timetable to it, there's a lot of effort that goes in pre the submission of an application for a DCO, isn't there?
Yeah, absolutely. And I mean, obviously one of the topical issues at the moment is how to make the infrastructure planning process go quicker. And there's been quite a lot of focus on the examination aspect, but actually, probably sort of 2/3 of the work goes in prior to the application even being made. So, most developers will do, several rounds of consultation, probably a non-statutory round, as well as the statutory consultation that's required under the Act. But there are, more statutory requirements for submission of an application under the 2008 Act than there would be under the Town and Country Planning Act. So, you gain certainty. And you gain, I suppose, a time-limited process, but that is at the cost of a lengthier pre-application process. So that's one of the issues, I suppose, that as a developer you have to weigh up, which is of more value. I think generally for developers, you would the certainty of timescale wouldn't be enough to justify the additional cost and probably a longer consenting process. I think you'd need to be in a position where you needed to use some of the additional powers that would be available. So as we've said, compulsory acquisition, or you need other consents that need to be rolled up into your into your one-stop consent process. I think this is probably something that the government does recognise. I mean, there have been consultations about, we talked about there are certain categories of NSIP that have thresholds over which you are automatically an NSIP. So over that threshold, you automatically require a development consent order. And of course, that creates a sort of cliff edge type situation, which can lead developers to modify the type, the scale of development that they are proposing. So this is very common, for example, in solar farm developments. So that the threshold for electricity generation is 50 megawatts. So you see a lot of 49.9 megawatt solar farms, for example, because at that sort of scale of development, that sort of just goes over the 50 megawatt, it doesn't make sense to go through the longer and more expensive process. So this cliff edge can influence the way that developments are brought forward. I think the government does recognise that. It's consulted previously, or floated the idea previously of increasing the thresholds in certain circumstances. But I was interested to see that in the Planning and Infrastructure Bill, there is a proposal for what I'd term a sort of reverse Section 35. So it's a new Section 35B of the Planning Act 2008, which would allow developers to apply for certain types of development to be excluded from the requirement of development consent. So that would mean that, for example, using solar farms again, if you wanted a 60 megawatt solar farm, you could make an application into Section 35B as it's proposed to have that removed from the DCO regime and put back into the Town and Country Planning Act regime. So, I think that the sort of direction of travel is certainly towards more flexibility for developers to choose which is the best route for them.
Looking at the Section 35 process itself, it's a relatively straightforward process. It is essentially you make your application to the relevant Secretary of State, setting out why you think your development should be an NSIP, and the Secretary of State makes up his or her mind and decides whether they're minded to do that or not. I think all the signals coming out of Whitehall at the moment are that the government is open for business, and it sort of seems to me that there's a desire to say yes. If developers want to bring forward DCOs, there appears to be a desire to say yes. So I kind of suppose there's an issue there around, well, why is the government talking about changes for data centers in particular? And that really comes down to the current criteria, because you can't ask for anything to be an NSIP under Section 35. Housing, for example, you absolutely can't. Housing has to go through the 1990 Act. But there's a sort of there's a bit of a grey area at the moment, isn't there, as to whether data centres are within the categories for which the Secretary of State can legally say, yes, I want this determined as an NSIP and to proceed through a DCO.
Yeah, that's right. I mean, so NSIPs have to be within one of the specified categories in the Act. As I say, in the sort of early 2010s, a new category was introduced, which is business and commercial projects. And there are certain types of business and commercial projects that are eligible to be NSIPs. I think, as we said earlier on, things like gigafactories and laboratories, I think, very clearly do come within the criteria. The types of development, rather. I think data centers are it's less clear. So I think it would depend as to whether you considered a data center, for example, to be an industrial process. And, obviously, you could sort of argue that either way. So I think the government's idea is to just make it very clear that data centers are a type, or either that they're a type of business and commercial project, or that they will introduce a separate category of NSIPs that are data centers. So I think it's just about giving that certainty. I mean, I think, all the signals from the government, as you say, are that the government would be delighted to receive Section 35 applications, because it seems as though ministers are very keen to have that decision-making power, in their own hands. I mean, I guess there are ways under the Town and Country Planning Act that that ministers can do that by sort of calling in planning applications and so on. But obviously the development consent order route under the Planning Act 2008 is a already established process. So for very significant developments, I can see why the government is keen to utilise that process.
And and so at the moment, I think the answer is the Secretary of State couldn't accept a data center as an NSIP. I don't know whether you agree with that, but when I look at the categories, industrial processes, well, that a gigafactory, I'm sure gets in under that. There's a research and development category. Laboratories would clearly fit into that, but data centers, to my mind, aren't an industrial process. There is a storage and distribution category, but that's quite specifically storage and distribution of goods, and that of goods makes me think that actually there is. It would be challenging. Whilst they're saying we're open to this, I'm not sure at the moment they legally can, which is presumably why they're looking to bring forward legislative change.
Yeah, absolutely. I mean, I think it's for certainty, isn't it? I mean, I think there are probably ways that you would argue depending on the sort of particular purpose, but like you say, it doesn't fit neatly in any of those categories. So, I think the government just wants to be very clear that this is something that that can be designated under Section 35. I mean, just sort of looking at it more broadly, I mean, there's absolutely no doubt, is there, over the next, sort of 5 to 10 years, that data centres will be nationally important in terms of the economic growth in the UK. So it's completely understandable that ministers want to make the process as flexible as possible. I think as a developer, you probably want as many tools as you possibly can get in order to deliver these developments, and particularly given that their size and scale is going to grow over the next several years.
And I think you sort of the there's not a timetable for the process of a Section 35, but the ones that I've done so far, it's been relatively quick. It doesn't get caught up on the minister's desk for months and months on end in my experience. I don't know whether that
yeah, I think that is I mean, very quick. I mean, I think that there actually aren't sort of huge volumes of them. So I mean, I imagine that helps them be sort of processed quite quickly at at the government end. But yeah, I mean, absolutely. And there isn't, although there are some sort of published criteria against which the Secretary of State will sort of judge applications. There aren't any regulations that set down a particular type of process. So yeah, I mean, but very quick, very flexible in terms of getting your Section 35 direction away.
Yeah. We've had some questions coming in. One that sort of touched on something we've already talked about briefly is the policy framework. So if you go down the DCO route for a data center, where or any other form of Section 35 approach, there isn't a national policy statement. There is for energy, there is for airports, and the other prescribed categories, but there isn't a policy statement for commercial NSIPs. So the policy framework is therefore a little bit less clear and certainly less certain than if you were bringing forward an energy project where you can in advance know and form your own view as to whether you are compliant with the relevant MPS or not. That's I think it's a fair comment, but sort of how does that policy gap get filled when the DCO is being considered?
So I mean, the normal process, as been identified there, is that there would be a national policy statement in relation to the relevant type of NSIP. And in that sort of situation, the Planning Act 2008 is very clear that the development consent order application should be decided in accordance with the relevant national policy statement, subject to sort of certain exceptions. Where there isn't a national policy statement, the situation is slightly different. So the Secretary of State will take into account important and relevant considerations, as they're called, under the Act. So, similar to sort of material considerations, I guess, under the Town and Country Planning Act. And so, the similar sort of things would be taken into account as in the planning system. So obviously there are, the NPPF makes provision for data centres. Another important and relevant consideration will be the local plan. So, in the same way as if you were having the application decided under the Town and Country Planning Act. And then, of course, there will be other wider national policy that maybe is not directed specifically to planning, but wider economic policy that can also be taken into account. So there will be the same sort of planning framework as there would be under the Town and Country Planning Act. The actual legal test would not be the same, so it wouldn't be a Section 38(6) type situation as under the Town and Country Planning Act. But the Secretary of State would be bound to take into account important and material considerations, important and relevant considerations rather, under Section 105 of the Planning Act 2008. So you would find that the policy framework would be quite similar to under the Town and Country Planning Act.
And I think there's certainly a point there around sort of when you look at policy. So you've obviously got your development plan, which is not sort of doesn't have the presumption in favour of it with Section 38(6), as you say, but it's clearly material and would be taken into account. But there is a point to make there, I suppose. It is just a material consideration alongside every other, one of which will be in England, and we're talking about England here with DCOs, the National Planning Policy Framework. And so there's a sort of a nuanced point there, but I think an important one. We have, as of the sort of December, or now slightly tweaked February version of the NPPF, particularly in the context of data centres, there's some new pro data centre policy that's in the NPPF, and at that point, the Secretary of State, number one, the Secretary of State always tends to have a preference for national policy because it's their own policy, so there's a sort of inevitable affinity towards it. But actually, you don't have that Section 38(6) hurdle to overcome of the framework having to outweigh the conflict with the development plan. Ultimately, they're both material considerations, and it's for the decision maker to decide what weight to attach to which. So if you have a situation where there's a restrictive development plan, and the development plan would be in favour of not allowing the development, but you have the NPPF that is potentially very much in favour of it, it's sometimes a little bit easier, I think, with a DCO rather than a planning appeal to sort of place more weight on the framework without having to worry about whether you're sitting within the rules of Section 38(6).
I mean, I think that's right. And I think that's where it's, it is quite difficult to sort of give general advice, isn't it, in these sort of situations, because I think it very much depends on the type of development that you are promoting, and where you're promoting it. What is the policy framework like in your local area?
Is there anything else on the Section 35 process that you wanted to add, Ian?
I don't think so. I mean, I think, as I say, just to sort of reiterate that point about the planning and infrastructure bill, which I found very interesting. It hadn't been sort of widely trailed, but there is sort of now going to be reverse Section 35. I haven't seen that much commented on, but I think I was quite. I felt quite reassured actually by that, because it seems quite clear that the government is going for maximum flexibility in terms of process, which is, I think is precisely what is required to try and avoid these sort of cliff edge type situations, which, definitely in the infrastructure space have, quite strongly influenced certain types of development.
And I think there's something interesting there, particularly in the context of data centres, where increasingly we're looking at on-site generation because there's just not enough capacity in the grid to deliver the scale of data center development that's needed. Actually, those energy thresholds can then trip data centers into having to be NSIPs. It's an interesting idea that if your energy generation is sort of effectively self-contained and it's not going to be basically public energy generation that's going to feed into the grid. It's going to be powering the development within your site. it might be that's an example where you could use that sort of anti-Section 35 approach to say, well, notwithstanding the extent of the energy generation on site, this isn't an NSIP and can continue down the 1990 Act. So that sort of other way round approach, particularly in context of data centers, I can see potentially being quite an interesting one for those developments where you'd rather not go down the DCO route, where you don't think it's necessary. You've acquired the land. There's policy support for data centers, and you want to stay within the 1990 Act.
Well, quite, and I mean, I think in some ways that's quite forward thinking, isn't it? In terms of as I said earlier, the way that this type of development may develop in the future. As power requirements grow, it may be that on-site generation requirements grow as well, to the point where they would go into the NSIP regime. So as you say, the ability to use a Section 35 in that sort of situation where you're not looking at power generation that would be for export to the grid necessarily, but just as backup, or just to power your data center on site. There might be an argument for removing that from the consenting regime. I guess it just depends on what the proposal is precisely, because obviously there are other regulatory requirements and so on that you might want to bundle up into a one-stop consent under the DCO process.
Yeah. Yeah, and just sort of pausing on that as a thought. I mean, an energy project. So one of the things with the DCO is the DCO is determined by the relevant Secretary of State, and if it's an energy project, then it's Secretary of State for Energy, currently Mr. Miliband. That's interesting. If it's the energy rather, so a Section 35 wouldn't go to the energy secretary. Whereas if it's the energy thresholds that get you there, you do end up from the energy secretary, and that might be something that you want to think about when you're thinking about a DCO, is to actually, who do you want making this decision? The energy secretary will have a different view on some issues than the business secretary, for example. So I think there's a thought there as to quite who your decision maker is going to be, who you want it to be, to the extent you can sort of control or influence it.
I think that's right. Now, I mean, I think obviously consenting becomes slightly more complicated in that sort of situation, because if a generating station as part of your development is an NSIP, obviously the relevant national policy statement for energy generation would apply to that part of the development, whereas there would be no national policy statement for the data center element, for example. So it does make a slightly more complex consenting process.
Yeah. That might be a good time to answer some of the questions that come in. We've had a few. One sort of follows on from that point, I suppose. The question is, if it's the energy generation that pushes you into an NSIP, does the DCO extend to the data center, i.e., would the data center be part of the development that consent, or would you then need a Section 35 in order to get the data center into the DCO regime and avoid it being a 1990 Act? I think broadly it would always be AD, wouldn't it?
It's a really, really good question. So I think so. The NSIP regime makes so. Start at the beginning. The data center wouldn't automatically be an NSIP, as we've already said, whereas the generating capacity would be. The NSIP regime allows for what's called associated development. So that is development that is not an NSIP, but it is related to the NSIP development itself. And when you look at the government guidance for associated development, I think it is not entirely clear that a data center would be associated development under the guidance. And I say that mainly because associated development is intended to be subordinate to the NSIP. Whereas obviously in this situation, we only need the NSIP because of the data center. I mean, clearly that's only guidance, and there's nothing in the legal provisions under the Act that would prevent, I don't think, the data center being termed as associated development. But under the guidance, it's not absolutely clear that it would be. Obviously, if you wanted absolute certainty, you could make a Section 35 direction. And I think, in those sort of circumstances, if the government changes the law in the way that it's proposing to, then there's no doubt that the government would accept a section, or would issue a Section 35 direction in those sort of circumstances. So I think there are two ways that you could do it. You would either ask for it to be associated development, or you would make a Section 35 application, but you would need to do something more. It wouldn't automatically be part of the DCO.
And it would probably be important that one way or the other, potentially it was part of the DCO, because the energy generation in and of itself may well not comply with the MPS. It might not have been envisaged by the MPS because it's sort of not the planned power generation that was intended. So you might need the DCO in order to justify the generation. So it feels like it would be slightly odd if you ended up trying to consider the generation in isolation from the data center, given that the whole rationale for the generation is the data center. So there's a certain logic to wanting at that point it all to be together. I suppose that there's a proximity point there, though. If your generation, the further away from the data center site it is, then perhaps the more difficult it becomes to say that it's associated development. Section 35 may well be available when the legislative changes are made. But there could be a proximity point. I'm sort of thinking if you had a solar farm 100 miles away from your data center site, one intending to power the other, that might get more complicated.
I think that becomes much more difficult, doesn't it? I mean, I think, in general, assuming that you're physically going to be quite close together. I mean, I think there are lots of reasons why you would want both to be dealt with under the same regime. I mean, not least, for example, it would mean that you would get a common set of requirements. So that's the planning conditions under Town and Country Planning Act are called requirements under the DCO regime. So that's one very important process. I mean, I think another sort of potentially another. I suppose it's a commercial issue, isn't it? But having two consenting processes running at different speeds, so firstly, I suppose introduces more uncertainty, doesn't it? But secondly, would there be sort of as much commercial value in having the data center without its power supply, if you see what I mean? That actually might not be as attractive for investors, for example. So I think there are lots of reasons once once one element of the project is in the DCO regime to have the whole project in there.
Yeah. Another question, although I think probably an easier one to answer, is a question as to are there any thresholds that require you to be an NSIP based on the level of consumption of power? So we've talked about the fact if you're generating over the thresholds, you're into an NSIP, whether you like it or not. Is there a corresponding sort of threshold for the amount of power you consume? And I think the short answer to that is no.
Yeah, it's no. The threshold is focused on generating capacity, so it would only be if you're generating your own power. Obviously, the other sort of thing would be electricity transmission. So connections to the grid, generally aren't promoted by data center developers themselves. But I mean, if it's over 2 kilometers, then that would be an NSIP. But no, not just purely consumption.
And usually, as you say, the connection is left to the statutory undertaker, so they may need a DCO for that, but that wouldn't. So just because your data center is more than 2 kilometers away from the substation, that wouldn't mean your data center gets caught. It means that the undertaker or whoever's delivering the connection may get caught, which of course may have timing implications for when you can energize the DC. But no, not a requirement for usage. Or threshold for usage, rather. Right, we've got about 5 minutes left, so we're doing well since we started 10 minutes late. We're covering this at pace, so well done, and thank you, Ian, for that. But a nice question that I've deliberately left to the end because I think it's a nice discursive one. From a public policy point of view, is the DCO mechanism the most effective means of achieving the UK's national goals on AI even? What's your view, Ian?
What a question. Is it the most effective way? Well, I mean, I guess going back to what we said earlier, I mean, one of the things that you can certainly say is that it is a time limited process. So we know that the Secretary of State the examination must take place within a limited period, and the Secretary of State must make a decision within a limited time. I mean, I do think with all of this stuff, and I mean, I think some of the net zero enabling developments fall into the same category. I think if we were really serious about delivering stuff quickly, I think that you probably need to look outside the current process. So I think my view on this would be, I've seen suggestions that we could have, data center zones where, there are permitted development rights or something similar that would allow, things to be built much more quickly. So, I mean, I think, it depends how quickly we want to move. If we want to move really, really quick, I think you have to take things outside the current system, because the current system, probably takes 2 or 3 years to get a consent. If we want to deliver stuff in 18 months or a year, tweaks to the current system and trying to optimize the current way of doing things are not going to get you to consent in a year. I think you would have to look outside the current system and to, innovative things like, a local development order for data centers that maybe encompasses things like, the grid connections and so on as well. I think, similarly with net zero, that would be the quickest and most effective way to do things. Obviously, there are political implications to trying to do that. And you've got to take into account, how long would it take to get regulations drafted or, legislation through Parliament. But I think if we were really serious, that's the approach that we would take. What do you think?
So I think for me, it's a really interesting question. And as with any good planning question, the answer is maybe. And it will depend on certain circumstances. It certainly could be. And I think if you look historically, data centers have been controversial. Why is that? Well, actually, one of the reasons for that is because certainly the sort of the hyperscale data center demand has been very much focused on that Slough to Hayes sort of corridor, Greenbelt, high concentration of other development pressures as well. And so there's been a lot of political opposition to a number of those sites. Once you get outside of the industrial estates of Slough, where it all began, it becomes more challenging. And so historically, the 1990 Act hasn't delivered very quickly. Having said that, we now have a very, very different Secretary of State approach than what we've had under certainly the last few years of the previous government. And actually, we have an appeal system at the moment that is working quickly. So the issue that exists or existed perhaps over in sort of Buckinghamshire and that part of the world has sort of gone away, because actually, if you put an appeal in, you could put your application in. 16 weeks later, assuming it's EIA development, appeal for non-determination, and 6 months after that, you could expect to have a planning permission in your hand because the appeal system is functioning. That won't last. Planning by appeal is clearly coming back into fashion, housing, 5-year land supply, and all of that. So the timescales at the inspectorate are going to go out, I suspect, because they will find a constraint on their resources, at which point a DCO might become the quicker alternative. But at the moment, it possibly, I'm not sure it is quicker than a fairly sort of bullish non-determination appeal and through the system. The other thing I would say is that the question was about AI. And the data center requirements for AI are less locational specific. You don't have to be in that Slough to Hillingdon corridor. If you're looking at AI can be delivered across the country. And so you're seeing data center developments moving out of those sort of that you've got that cluster to the east of London for financial services. You've got hyperscalers to the west of London. But traditionally, you haven't looked for data center sites further north, the Midlands, the north, and Scotland, elsewhere. When you get out of those areas where the pressure has been most, actually the politics is different as well. there isn't the resistance. And I'm certainly seeing from my clients, local authorities wanting. You're talking about high-tech development. You're talking about whacking great big business rates that come from these buildings, relatively low traffic impacts. It's a pretty good economic growth generator for some of these areas. So actually, for the AI agenda, where you don't need to be in those areas where there's perhaps more political hostility to more data centres, I'm not sure you need the DCO. I think actually a planning application is quite often going to be welcomed, and you can see that more and more. Local authorities are actively talking about, identifying sites where they want to see data centres come forward to bring that investment into their areas. So it's certainly part of the way that we deliver that AI agenda. But it's not necessarily the only route, not necessarily always the best route. I think it will depend, as ever with planning, it will depend on the particular circumstances of your site and the politics and the planning policy framework that sits around it in a particular area. So for me, I'm going to go with the good old planning maybe. It was a very long maybe, which has taken us on to the hour. So we always make sure we finish promptly, notwithstanding the technology issues at the beginning. So thank you to everyone for their questions. There's really good questions there. Ian, thank you very much to you for joining me. Apologies again for the technical issues at the beginning, but I think we covered, albeit a little bit quicker than we planned, we covered everything that we wanted to say. So hopefully we can be forgiven for the technical issues. We'll be back with our next outline very shortly. But in the meantime, thanks again to you all and goodbye.